Hey everyone, and welcome to this explainer. If you're a focused learner looking to understand how the law actually operates on the ground, you are in exactly the right place. Today, we're going to absolutely demystify India's criminal procedure. Look, if you've ever stared at the thousands of sections in the Bharatiya Nyaya Sanhita, the BNSS 2023, and felt completely overwhelmed, don't worry, I get it. We're going to take a highly logical step-by-step journey through the entire criminal justice system. We'll translate that giant wall of legal jargon into a clear, understandable, everyday process.
Quickly, here's our roadmap for today. We'll follow the exact timeline of a criminal case, starting with the foundation, which is recipe versus cooking, then we'll hit the trigger, types of offenses, moving on to the gateway, filing the FIR, then the rights, arrest safeguards, the freedom, bail versus jail, and finally, the judicial ladder, courts.
All right, let's dive right into Section 1, the foundation, recipe versus cooking. Before we start our actual timeline, we really need to nail down the fundamental difference between India's two types of criminal laws.
So, to really grasp this, think of criminal law in India as being split right down the middle. On one side, you have substantive law. That's the Bharatiya Nyaya Sanhita, or the BNS. Think of the BNS as your recipe book. It defines exactly what the dish is, right? It tells you, hey, if someone steals, that's theft, and the punishment is 3 years. Pretty straightforward. But the police don't just read the recipe book and suddenly teleport someone into a jail cell. That's where procedural law kicks in, the BNSS 2023. The BNSS is the actual cooking process. It dictates the exact, precise steps the police, magistrates, and judges absolutely must take. How do they write the complaint? How do they make the arrest? How does the trial actually run? If you don't follow the cooking steps correctly, well, the dish is completely ruined. In the legal world, if the police make a procedural mistake under the BNSS, the entire trial can collapse. Literally, a real, factual criminal could walk out of court completely free just because of a technicality. That's why procedure is absolute king.
Okay, now that we know we're looking at the cooking process, let's look at Section 2, the trigger, types of offenses. A crime just happened, but what the police do next depends entirely on the category of the offense.
Under the BNSS, offenses fall into two totally distinct buckets, and the difference here is vital. First up, cognizable offenses. These are governed by Section 173 of the BNSS. We're talking about serious crimes against society here: murder, kidnapping, robbery, the heavy stuff. Because of the severity, the police are granted massive power. They can register an FIR immediately, and critically, they can arrest the accused without waiting around for a warrant from a magistrate. The investigation starts instantly. It's like a fire emergency in your house. The fire brigade doesn't knock or ask for permission, they just rush in. On the flip side, we have non-cognizable offenses, governed by Section 174. These are your less serious crimes like defamation or simple cheating. Here, police power is heavily restricted. They can't arrest without a warrant, and they can't even begin an investigation without explicit permission from a magistrate. They basically just record it and point you to the court. This one is more like a minor plumbing leak. You call a plumber, you make an appointment, and you resolve it systematically.
Let's assume our hypothetical crime is a serious one, which brings us to Section 3, the gateway, filing the FIR. Here, we run into the ultimate gatekeeper of the whole criminal justice system.
That gatekeeper is the FIR, the First Information Report, under Section 173 of the BNSS. Without it, the formal machinery of the law just doesn't start. But the new BNSS introduces a super modern feature that's absolutely crucial for citizens to know about, the E-FIR. You can now actually report a crime digitally, via SMS, email, or an online portal. But there is a massive catch to prevent fake complaints: 3 days. If you file an E-FIR, you have exactly 3 days to physically visit the police station and sign it. Only when you put pen to paper does it become a formally registered FIR. And this brilliantly highlights a core principle of justice, famously cemented in the landmark Supreme Court case Lalita Kumari versus Government of UP. The rule is rock solid. It was serious cognizable offenses disclosed, the police must register the FIR. No exceptions. They can't turn you away. They can't make excuses to delay it by saying, well, we need to verify if the story is true first. The mandate is super clear. Register the complaint first, investigate the facts later.
So the FIR is locked in, bringing us to Section 4, the rights, arrest, safeguards. The next logical step is obviously an arrest, but this is exactly where the BNSS steps in to balance state power with your individual liberty.
Look, even when someone is accused of a truly terrible crime, a person in India is presumed innocent until proven guilty, and they retain some powerful constitutional protections. Think of this as a vital toolkit for personal liberty. Under Section 47 of the BNSS, an arrested person has the right to know the exact grounds of their arrest immediately. The police can't just pick you up blindly and throw you in a van without explanation. No way.
On top of that, Section 48 guarantees your right to inform at least one friend or relative about your arrest, so someone out there knows exactly where you are. These sections actually draw heavily from the famous D.K. Basu versus State of West Bengal case. That case sets strict guidelines to stop custodial abuse. Things like mandating that police officers wear clear, visible ID tags and prepare formal arrest memos. So the takeaway here is that the procedure is designed to protect citizens from completely unchecked police power.
And speaking of unchecked power, there's a strict ticking clock you need to know about, the 24-hour rule under Section 58 of the BNSS. Once arrested, the police cannot just lock you up indefinitely. They are legally required to present you before the nearest judicial magistrate within exactly 24 hours of that arrest. If the police feel like, hey, we haven't finished our interrogation, we need to keep them longer, well, they can't make that call themselves. They have to formally ask the magistrate for remand under Section 187 of the BNSS. It's the judge, not the police, who decides if further custody is truly justified.
The clock's up. You're before a judge. Let's move to Section 5, the freedom, bail versus jail. The immediate question is, do you stay in a jail cell or do you get to go home while you wait for your trial?
This brings us to the whole concept of bail. Justice Krishna Iyer famously said, bail is the rule, jail is the exception. But applying that rule, that completely depends on how your crime is classified. Under Section 478 of the BNSS, if you're accused of a bailable offense, bail is your absolute legal right. Period. If you can provide the required bail bond, the police or the court must release you. They literally have no choice. But if you're accused of a non-bailable offense under Section 480, freedom is no longer guaranteed. It's now entirely at the judge's discretion. The judge is going to carefully weigh the situation. How grave was the crime? Is there a risk you might hop on a plane and flee the country? Might you intimidate witnesses or mess with evidence? Based on all that, the judge makes the final call between bail or jail.
But what if you haven't actually been arrested yet? What if you hear a rumor that a fake complaint has been filed against you and you know the cops are on their way? You don't have to just sit there waiting to be handcuffed. You can actually seek anticipatory bail under Section 482 of the BNSS. Think of this as a preemptive insurance policy for your personal liberty, protected under Article 21 of the Constitution. Like the landmark Gurbakh Singh Sibia case established, if the court grants you anticipatory bail, you carry that order with you. When the police show up to arrest you, you just present the order, and they are legally obligated to release you on bail right then and there.
Progressing our story to the final stage, we hit Section 6, the judicial ladder, courts. The police have compiled all their evidence. They've filed a formal charge sheet under Section 193 of the BNSS. The investigation phase is officially over, and we step into the courtroom.
Now, you don't just waltz into any random court. India has a very strict judicial ladder, governed by Section 6 and 23 of the BNSS. It's essentially defined by how much punishment a specific judge is legally allowed to hand down. At the very top, you have the Supreme Court and High Courts. They can pass any authorized sentence. Just below them is the Sessions Court, handling the heaviest trials like murder. They can also pass any sentence, but with one huge caveat. If a Sessions judge hands down a death sentence, the High Court absolutely has to confirm it before it can be carried out. Moving down to the magistrate levels, we've got the Chief Judicial Magistrate, who can issue up to 7 years in jail. Below them is the Judicial Magistrate First Class, handling cases up to 3 years or a 50,000 rupee fine. And finally, the Judicial Magistrate Second Class deals with minor offenses, maxing out at 1 year in jail or a 10,000 rupee fine. But notice something really cool and brand new at the bottom here. The BNSS has officially introduced community service as a formal punishment that magistrates can hand out. It's a massive modernization, shifting the system towards rehabilitation for those minor offenses.
Actually, as a quick aside, it's worth noting what's not on that ladder anymore. The BNSS completely abolished the categories of assistant sessions judge and metropolitan magistrate, just totally removed them. This was a very intentional move to streamline the hierarchy, cut out the bureaucratic red tape, and frankly, make the justice delivery system a whole lot simpler and faster for everyone.
So let's just take a breath and look at the whole picture. What initially looked like a scary, overwhelming list of thousands of sections is actually just a logical, chronological journey. A crime happens, which triggers an FIR under Section 173. The police might arrest the suspect under Section 35, but they are tightly bound by the 24-hour limit of Section 58. Then the accused fights for their freedom through bail under Sections 478 or 480. Meanwhile, the police are wrapping up their case with the charge sheet under Section 193, pushing the battle onto the appropriate rung of the judicial ladder under Sections 6 and 23, and culminating, finally, in the trial and judgment. By walking through these steps together, you can really see that the law isn't just a bunch of arbitrary rules. It's a carefully engineered machine.
Which leaves us with a final, provocative thought to ponder. If procedural law truly is the recipe for justice, the exact steps we absolutely must follow to ensure fairness, how well do you think this new BNSS recipe balances the overwhelming heavy power of the state against your own individual personal freedom? Understanding this process isn't just a hobby for lawyers, it's quite literally the ultimate tool for protecting your rights as a citizen. Thank you so much for joining me on this explainer, and definitely keep learning.